Morning, Ms. Hill.
Good morning. I apologize to everyone at this point for being late. In my own backyard, and I can get to Tallahassee quicker than I can get to Coral Gables, apparently. My name is Kimberly Hill, and I'm here on behalf of the claimant, Kimberly Jones, and sitting here at council table with me is the trial attorney, Mr. Larry Melman. This is the case involving an exposure to mold, and in this particular case, the main issue revolves around the sufficiency of evidence. And in this particular case, we're dealing with a heightened standard of review, obviously clear and convincing evidence standard, which came about in 2004. There haven't been many cases decided on this standard, and the two cases that I found that have been decided, in fact, don't really directly impact this particular case. Here, it's asserted that the judge of compensation claims erred in finding that the claimant's exposure to mold was not a compensable incident. He did find that he was not convinced without hesitancy that the claimant's exposure to mold was the major contributing cause of the pulmonary problem. However, and typically, I understand that this is typically reviewed on a competent evidence standard, but in this case, it's asserted that the judge of compensation claims findings actually are not supported by competent evidence, realizing also that the employer carrier has no burden of proof. I'm just going to step back for a minute and state that I think that the judge of compensation claims here actually applied the wrong standard. He did allude to the proper standard, but unfortunately, under 44009, he relied on some factors that are insignificant, and I'll get into those factors a little bit later. But let me just start with the unrefuted evidence in this case. The building where the claimant worked, including the suite in which she worked, had a significant and abundant mold problem. There's no question about that. It's absolutely unrefuted on this record. The mold analysis done in the claimant's building suite revealed 10 times the amount of mold in the building as outside of the building on the same day. The mold analysis revealed Penicillium aspergillus, commonly implicated in pulmonary problems. The claimant had an allergy to mold. It was ultimately determined via an allergist. Both experts agreed, including the employer carrier's expert and the claimant's expert, that the claimant's allergy actually had an allergy to mold as a result of the workplace. There's no dispute about that. The only real question is whether or not the claimant met the major contributing cause standard in terms of whether the allergy to mold caused her pulmonary problems. And the reason that the judge indicated that she did not meet the standard was because they did not rule out, that the claimant did not rule out that she had GERD and or sleep apnea, which are other potential causes of pulmonary problems. In this case, there was a preliminary diagnosis of GERD and sleep apnea as possibilities. This is long before the claimant ever knew that there was a mold problem in her building. She simply was going to the doctor to try to find out, what was wrong with her. She was having significant allergy symptoms and pulmonary problems, and so it took months and months to determine it, and it was kind of odd actually how the situation came to light in terms of the mold problem in the building. Basically, the claimant went to a cardiologist to get clearance to have a pulmonary function study, and the pulmonologist happened to be a doctor who used to be in the same building where the claimant worked. And the pulmonologist indicated that, hey, by the way, did you know there was a mold problem in your building? So the claimant said no. So she immediately went back, reported this to her employer, and also the very next day had an appointment with her pulmonologist and advised him of the same. Ultimately, he sent her to an allergist for allergy testing, at which point it was determined that she, in fact, did have an allergy to mold, among several other things. So, in the end, Dr. Bernstein indicated, and that was her treating doctor, indicated that there was unequivocally a causal relationship and that the exposure to mold was the major contributing cause of her problems. On the other hand, the employer carrier's expert said that he agreed she had an allergy problem. She agreed she had an allergy to mold. He agreed, in fact, that the allergy to mold could cause the pulmonary problems that the claimant had, but he was not 100%, well, I guess he said he was not 75% convinced that, in fact, the allergy problems were the cause of the mold problems, just because of the fact that the other conditions were not ruled out. And this is where the judge of compensation claims made his mistake. 44009, in essence, says that the claimant has to prove that the major contributing cause of her problems are obviously the work cause. In this instance, that's as compared to all other causes. It's not as compared to all other possible causes, and the claimant was never diagnosed here in this case with either GERD or sleep apnea. Initially, they were diagnoses that were thrown out as preliminary diagnosis, trying to figure out what was wrong with this claimant and why she was having the problems that she was having. And this is long before there was a claim ever filed for workers' comp. So ultimately, the judge, in essence, based his findings on an improper standard, because there's no requirement at all that a claimant have to rule out any possible cause of injury. I mean, if she has another cause, then that's significant.
Ms. Stoll, I mean, it is your burden to convince the JCC that this is the cause, right? So if there is a suggestion that there might be other causes, don't you decide not to explore those at your own peril? I mean, if they leave a doubt, because it's not whether or not the JCC could have found in your favor, it's whether or not there's evidence to support what the JCC did find, and when it's a lack of persuasion, we don't even need evidence usually. I mean, so the fact that these questions are lingering out there, is it the sleep apnea that causes the pulmonary problems, or isn't that a legitimate inquiry on the JCC's part?
Well, actually, based on 44009, I don't think so, because if you're looking at it from the other perspective, you're looking at it, if you're looking at it as a burden of proof.
So
if you go in and
establish major contributing cause under 44009, and I really want to serve the best interests of my client, I explore absolutely no other cause at all, and I object at the hearing if the employer carrier starts to suggest some other cause. Judge, there's no evidence. The only one we're going to focus on is the work cause.
Well,
I mean, if you actually were to explore other causes, you potentially jeopardize your client's case, wouldn't you?
Well, that's correct, but actually, typically what happens, this is kind of the reverse of a normal scenario. Typically, what happens is a claimant has a diagnosis, or maybe has a pre-existing condition, for example. I guess this is the easiest way to explain it. Has a pre-existing back condition and subsequently injures her back, and then the question becomes, well, is the pre-existing back or the current back, is the current back problem at least 51% of the problem as a result of the accident? And this scenario is a little bit different. The claimant was never diagnosed with these conditions by any objective findings. They were just, in the initial stages, thrown out there as possibilities. So I don't think that the claimant, I think it's imposing almost an impossible burden on the claimant. It would mean that the defense could bring up at any particular time in a case, well, she might have this or she might have that, but there's no objective documentation in this record that she did in fact have those conditions. They were just thrown out as preliminary diagnosis, never ruled out, never ruled in, agreed for certain, but if there's no other evidence presented that she did have these conditions and that they could impact her condition, then obviously the most logical thing, even, all the doctors agreed, including the employer carriers expert, that this condition can certainly be caused by the claimant's exposure to mold. And there's no question that there was exposure to mold. So the question becomes, how far do you have to go to prove the case? Do you have to rule out every single possible condition that could cause the pulmonary problem or a problem such as the claimant had in this case? And I don't think that's what 44009 stands for. I think 44009 says what things are related to this incident, to what conditions does the claimant have that could impact, what does she have objectively? And the entire workers' comp statute requires us to prove by objective evidence conditions in order to get them compensable to begin with. So how could it be that we could go the opposite route on this situation and say, well, she might have this, but we don't know if she has this, and therefore you don't meet your burden of proof? It really doesn't make any sense. I mean, in all honesty, it has to be a situation where you have proof objectively that she has these conditions. So just getting back to some of the other findings in the order, I mean, the judge of compensation claims findings also throughout the entire order are, well, let me just step back for a minute to the clear and convincing evidence standard. It's our position that no one really could reasonably find that the claimant did not put forth competent evidence to meet the clear and convincing evidence standard in this case. There's several elements that were set forth by this court in Matrix Employee Leasing versus Pierce, and the elements as set forth in that case are really that the claimant, the evidence must be found credible. In this case, the judge of compensation claims clearly found that the claimant was a credible witness. He believed everything she said. That didn't somehow make it into the order, but it was in the ruling letter. That's also part of the record. The memories of the witness must be clear and without confusion. The JCC found the claimant well organized and conscientious, and the sum total of the evidence must be of sufficient weight to convince the trier of fact without hesitancy. I know he said he wasn't convinced without hesitancy, but Dr. Bernstein unequivocally testified that the major contributing cause of the claimant's problems were, in fact, the mold exposure. Now, the judge made some findings throughout the order. One of the findings was that Dr. Bernstein felt that there were some other factors, but that is definitely not his testimony. It's not in line with his testimony. And as well, I think his name for a second, just went out, I apologize. Dr. Reed, who the judge relied on significantly for his opinion, testified that I think the testimony became a little confused if you actually look at the record, and basically the counsel for the defense at the trial was asking the doctor in such a manner that, I'm not sure, I wasn't confused, but he would ask the doctor, are you 75% sure that mold is more than 50% responsible? And I'm not quite sure where that standard came from, but there was a whole line of questions which I outlined in my brief that kept reiterating that standard over and over again, and finally the doctor said, yeah, I think I understand, no, I'm not 75% certain. And again, I realized that there's no burden of proof on the employer carriers, but at the same time, the evidence relied upon by the judge to support the denial, has to be supported by the record and has to also be supported by the law. I think I'll reserve my remaining, I forgot to say it at the beginning, but I'll reserve the remaining for rebuttal if you don't mind.
That's fine.
Thank you.
May it please the Court, I'm George Kagan speaking on behalf of the employer carrier, the Appellees. It is good that claimant concedes the governing standard of proof in her brief at page 27 in an oral argument. That gets us off to a good start, because the standards of proof in this case do govern the Court's disposition of the evaluation of the judge's actions. Since I'm going to take some of the comments that were made, because the claimant focuses on them in the order that she raises them, but I would start with a lay person might have been impressed with this hearing, with the claimant's evidentiary presentation. A lay person might have given the claimant the nod, but the particular legislative hurdles that have been thrown in precisely claims of this kind evince a kind of legislative skepticism that has resulted in that interposition of a higher burden of proof, which has been acknowledged. So the lay person would not have been so informed, and the doctors upon whom the claimant relies were I'm going to use the phrase old school. They were more apt to draw the line between, the imaginary line between preliminary data and an ultimate opinion. And the statute as it's currently configured does not actually ask so much of the doctors their opinion, but asks of them really to relate the medical evidence. They are relators of medical evidence. And the claimant has tripped on that particular finding, and her doctors have relied on, they got this and that, and then based on their 20 years experience, they conclude such and such. But there was much more here than the claimant gives deference for in the record. Now, when she talks about the 10 times the mold content in the building from without, that is essentially a medical non sequitur. That was explained by Dr. Reed at page 394. It doesn't signify anything. I can tell you that I-95 is Florida's most dangerous highway, and it's its safest highway. It depends whether you're talking accidents per mile or number of accidents on a named road. So 10 times, I'm sure there's 10 times more dust in here than outside. Dr. Reed explained this is not independently significant. This, to me, symbolizes a lot of the deficiencies of the claimant's evidentiary presentation.
Could the JCC have found in favor of the claimant on this evidence?
I have not altered my mindset to go there, but I'm going to concede probably for purposes of argument that had the judge been persuaded, yes, I'm going to say this, the claimant did not carry, regardless of the preliminary steps, the claimant did not carry her ultimate burden of persuasion here on, let's call it a closed case. And that is where the court must give the judge the ultimate deference. If the court would have arrived at a different conclusion, still the court must have given the judge the deference unless there is a serious flaw that can be articulated. And the punching at the issues is not going to cover it. For instance, the gastroesophageal reflux disease, that she says there is no evidence of this. Well, you know, we see other planets that are very distant with our telescopes by the gravitational effect of other bodies around them, even though we can't see the planets. Dr. Reed was not obliged to diagnose GERD. What he noted was, and this is at page 370 of the record, she was receiving the strongest possible treatment, the prednisone, for the disease GERD, and he assumed this was not done arbitrarily or cavalierly. This was the strongest regimen of care implemented for GERD, and GERD is a disease, just like her asthma. It's a pre-existing condition, and that satisfies that criterion. And the judge noted that the sleep apnea, claimant points out there's no evidence of sleep apnea. Well, her own doctor said probably she does have sleep apnea. That's at 168 in the record, based on husband's anecdotal evidence of her sleep patterns. That's in the record. Now, even if you say, well, that wasn't proven with a certainty, it doesn't matter. The judge heard that, and the judge could draw reasonable inferences from that, and the judge did do that. And that cannot be second-guessed on appeal.
The judge doesn't have to find that she has sleep apnea in order to have this evidence of sleep apnea cause him not to be persuaded. I mean, I guess my point is, aren't we really just concerned about what did Judge Harnage determine? Was he persuaded? And was that a permissible conclusion that he reached, right? That
is correct. The judge found that there were many causes. The claimant could pick off some of them at a shooting gallery, but there were still other causes that persuaded the judge that this was not the major contributing cause. Now, I have an analogy, if you will. There's an interesting case. Now, you know, if I were the claimant, I'd pound the table about the doctor felt she had an allergy to mold, among other things, and that there was even comment about maybe she shouldn't work in that place. And I was expecting that to be a central theme, but I'm going to take it up as if it were, because I think it's an interesting point. There's an old case, and I was involved in it, and so was Mr. Sinking in the room, Schwartz versus Florida Ordinance, and that's 472, 7th, 2nd, 853. It's cited in the brief.
You got Mr. Sinking scratching his head back there.
Well, talk to me after the argument. Anyway, in that case, the claimant had a problem with her work, and she was advised to try other work. And she brought her claim and says, if I'm having pains and I have to be told to go somewhere else, that's a claim. And the court found there was no injury documented in that case, but that the work was contraindicated for her frail body. She was lifting 75-pound tank windows. Does that ring a bell? Anyway, my point being that if an employee has a problem that does not satisfy a statutory criteria for compensability, it may be in that employee's best interest to work elsewhere. But that fact, and that's an extreme example I'm giving, that she might be told to work elsewhere, that fact, or that reasonable prescription or proscription, does not render the claim compensable. If you have a peanut allergy, it's not recommended you go to work for Planters. But if you do that, and you have a respiratory condition that results from that, and this is an extreme example, peanut allergy, are you going to say that the peanut was the major contributing cause of her respiratory distress that afternoon, or the underlying pre-existing disposition to having this allergy? So it was the pre-existing condition that set her up. You could say that the respiratory ailment that is suffered at the workplace was the last contributing cause. It was the catalyst, but the legislature tried in 94 and made it abundantly clear in 04 that it must be the major contributing cause. And that did not persuade, and Dr. Reed, you know, we talk about 75% question, and that was probably an inappropriate way to put the matter to the doctor. That was an offhand description by the defense counsel trying to describe the interactions of 440.091, the clear and convincing evidence standard. And first I would like to say that counsel waived any objection to that particular formulation of the question. This is not a problem that has been articulated in the Fauscher case, which was even repudiated by the Tampa case, where missing facts should have been supplied. This was not a missing fact question. This was the formation of a question which was not objected to except for one objection, and that was it invaded the province of the JCC to ask that question. After that objection was raised, the questioning went on, and they talked about the 75%, but the point is, number one, you have a 29-page report of Dr. Reed, very thorough, not impacted at all by that. The conclusions that were sound in that report were in the deposition. The offhand remark made by counsel in trying to formulate a verbal picture of the statutory requirements did not impress the judge. He made no such reference whatsoever. And I point out to Your Honor that
you bring up an interesting point, that if the JCC had relied on the 75% question in making its decision, and clearly that would be a wrong legal standard, even if there wasn't an objection, we could reach that, couldn't we?
Well, Your Honor, the judge is not a jury. The judge is an informed adjudicator of workers' comp injury. And to have heard that extraneous comment by counsel, to not have reported it, to not have that comment impacted in the doctor's report, you're asking a pure hypothetical.
I understand what you're saying, but you indicated because there was no objection that couldn't be raised.
Well, if that, let's call it a virus, invaded the order, and if you saw an explication of a new standard, 75% standard, then we would have a serious issue, and then I would be arguing tipsy coachman, that the judge arrived at the conclusion, perhaps indirectly, but ultimately correctly. But that did not happen. There isn't a scintilla of the virus evident in the judge's order. There is none communicated in the doctor's report. And the judge is not a jury. As I said, it's not that he heard the wrong thing, and we must now try to repair that damage. The judge is a seasoned adjudicator of workers' comp industrial injuries. That is a red herring or a straw that has been grasped for lack of other substance to bring to the court, if I must respectfully submit. I hope I've addressed that concern, but I don't think it impacts this case, because it makes it finds no out in the judge's award letter where maybe the drafter expunged it. And the judge's award letter is an interesting document because I think it's
before you go on this case,
please.
You raised the red herring of an objection. That's what got us going down that road.
All right.
But that's not the case here.
You mean
the judge did not rely on it?
No, of course it didn't rely on it. There's no evidence whatsoever that the offhand remark of counsel during questioning and trying, the Workers' Comp Action Act is not, and I hope industry is not listening to me at the moment, but it's not a model of clarity in all its various permutations. And sometimes the doctors, they don't have major contributing cause courses at the medical school here. We're all trying to wrestle with this stuff, but we get a pretty big picture of what the story is, and I think that is a small item on today's agenda, and I've tried to articulate why in reasonable terms. I'd like to go into the doctor's opinions. I mentioned a moment ago that the mold is a big red herring in itself. It's a target. It's an easy target. And the judge articulated reasons why the doctor's reports were not very persuasive. He pointed out irregularities even in the manner of their having been compiled. There was an alteration, an amendment, and I want to point out to you that you'll see that discussion in the briefs. And the point is that it is not as though something of medical significance caused the doctors to amend the report. The reports were simply amended as report, not because of an intervening medical knowledge that had been acquired in the interim. They were, in my mind, and the way I would describe it, they were drawing that imaginary line between their 20 years experience and a predicate of some data, which I submit to you doctors may do day in and day out. I'm not going to judge. But the statute in this case wants something better. And it wants, and we don't have to get into all of the statutory nomenclature unless the court would like to, but it's written pretty nicely on page 27 of claimant's brief. And the evidence did not produce this firm conviction without hesitancy as to the requirements of the law articulated in 440.091 and 440.01, dealing with this particular exposure, clear and convincing evidence. And the doctors that when they draw this line saying, well, I've looked at some preliminary data and I say it's this, That's a common scenario. And Dr. Reed, when he's asked, well, would you defer to them? He says, I want to see their reports. Then I'll tell you if I defer to them. And that, I think, is attuned to the statutory prerequisites. As I said, the legislature has said we don't want the doctor's opinion so much as we want the medical evidence only. And that is not what was given here to the satisfaction of the judge of compensation claims. That claimant has satisfied her high burden of persuasion conceded at the outset of her argument in this particular case. And I find there is no cognizable basis upon which this court could enter an order reversing the judge's disposition of this difficult case, notwithstanding what the layperson in the courtroom might have thought that morning. Thank you very much, Your Honor. We ask that you affirm the order of the judge of compensation claims.
Thank you. Dr. Reed indicated that there was a work-acquired allergy to mold. He also, and this is the employer cares expert, he also indicated that it was a cause of her pulmonary problems. He could not opine that it was the major contributing cause just because of the fact that he did not know whether or not she had GERD or sleep apnea. He thought she did based on her symptoms, but the same symptoms can cause the problem, the allergy to mold can cause the same symptoms as GERD or sleep apnea. There are tests that can be done. They weren't done in this case, and the reason I believe that they weren't done is once the claimant's treating physician finally found out that, in fact, she had an allergy to mold, he thought that no further inquiries were necessary at that particular point in time. The problem with this case is that the judge relied upon Dr. Reed's testimony that he could not establish major contributing cause. And as Mr. Kagan indicated, the standard is the major contributing cause. So the major contributing cause implies that the claimant has other related or other causes to this condition. And there was no record evidence establishing that she ever did have any other cause. So that's where I think the mistake lies in this particular case. Relying on a doctor who said, I can't establish major contributing cause only because these factors are missing. But those factors, if she had them, would be relevant to this case. If, in fact, somebody said you have an allergy to mold and you have sleep apnea and you have GERD or any combination of the two, then the decision would make sense. But in this case, there was no objective medical findings supporting that she had GERD or sleep apnea. I thank you for your time. We respectfully request that you reverse. Thank you.
Thank you.